Your Lordship, in respect to the relationship that were drawn, both for the presiding judge and Justice Mrima, the charge is that of deliberate failure to disclose the relationship. That my lords, you are aware at the time of the inception of the case that Justice Mrima is closely associated to one of the parties, but he deliberately failed to disclose. Equally well, the presiding judge was well aware at the inception of the case that his spouse is greatly connected to some parties in the proceedings, but again failed to disclose.
You should tell which parties. You say clearly, if you can't understand what you are doing, please go to your affidavit and read the affidavit again.
My lord, I then
reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes, Your Lordship. You have an affidavit, Mr. Ndengwa. If you can't understand what we are talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 of the judgment of the ruling in Havi. The judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that brings confidence to the parties that appears before a judicial officer. Lordship, it's our humble submissions that confidence has been eroded. Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution, and no petitioner herein has the capacity to direct the Chief Justice who constitutes the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose these material facts. I invite the proceed.
Lord, while during the course of, I guess we've been here for about 5-6 hours when this application has been going on, and there are two things that have been crossing my mind. Lord, the first issue is the issues of substance and the issue of perception, the optics. What will be the optics? The optics, my Lord, as we sit here in public, in the glare of Kenyans, some of whom, if you use the reasonable test, are professionals, people who have studied about from 4, probably half the population. The other half of the population are people who are definitely not from 4. So, what's the reasonable person's test here? What are they seeing? The first thing my lords and my ladies are seeing is that the petitioners appear to be categorical for good or bad reasons, that they do not have confidence in the bench. And examinations of the fact may still prove that they may or may not be wrong. But the issue is the test, as far as when you read all these cases, in matters particularly that have some political angles, perceptions is everything. And perception is a big issue. So that, my lord, the issue therefore would be, shall we proceed on the basis where from the word go, the petitioners clearly have appeared to the rest of the country, they have got more confidence. With the same zeal and spirit, the respondents who are being accused for good or bad reasons are saying, we have full confidence in them. That should trouble us. Because at the end of the day, it is the declaration of whatever decision is made. It will be done from the prisons. Oh, we told you, we knew this, they were going to do this or the other one. In huge cases like this, it should never be that way. I go to the second issue, the issue of the Honorable Attorney General. I listened to the Honorable Attorney General. The Honorable Attorney General has made an application, one of the applications to set aside the orders. I went back to Article 156. 156, on one hand, suggests the Attorney General is the President's lawyer. There is another clause, I don't know whether it's 11 or something like that. It suggests that the Attorney General is the guardian of public interest. And you ask yourself, the Attorney General, without doubt, when it becomes to the President, he's 100% sycophantic a President's lawyer. But
no
when it comes,
a new issue, that
which
issue
is
was
a new
never
issue.
part of the recusal application.
That is not a new issue. Let me proceed. Well, the Attorney General is the guardian of public interest. What is the public interest in a process of impeachment as we stand here today? Well, that public interest must be the country has been treated with an imperfect, I'll not go to the details, with an imperfect impeachment process at the National Assembly and at the Senate. When it reached towards the tail end of this process, the public will be treated to the fact that in the processes that presupposed that you would take about 75 to 100 days were conducted within hours. So that the bigger questions, my lord, would be that there is a complaint that is being made, a serious one, of the right to fair hearing and human dignity. Rights that are not derogatable under the Kenyan Constitution, even during an emergency. My lord, if you are faced by an Attorney General who, pursuant to one mandate, their conscience has not been touched, that there is some public interest in looking at these things a little bit from the perspective of the Deputy President, and those who feel like the Deputy President, that a fair and square deal has not been granted by the processes that have taken place. Your Lordships, that should concern us.